BBC Radio Scotland.
It's 24 minutes to 7. A legal fight back against the Scottish Government's plans to assign state guardians for every child is set to get underway. The case at the Court of Session in Edinburgh is part of a judicial review of the Children and Young People Act, which assigns a named person to help protect every person under 18 years of age. Now, that individual, usually a health visitor or a senior teacher, becomes the first point of contact for advice and support. And speaking back in February, the SNP MSP Stuart Maxwell of Holyrood's cross-party group on violence against women and children said the role was not a threat to family privacy or parental control.
It's the primary job of parents to do that. But of course we all know that in some cases parents need extra support, families need additional support. But let's take an analogy. If you have an insurance policy on your house, it's not because you expect something terrible to happen to it, but just in case you have it. So that will be there if it's needed, when it's needed, it's additional support, and it's needed of course when children are in vulnerable situations. For the vast majority of parents and families, they will never come across this named person.
Well, in our Edinburgh studio now is Simon Calvert of the Christian Institute, one of the organisations which is bringing the action. Good morning to you, Simon.
Good morning.
So what's your legal basis for this then?
Well, the legal basis is that our lawyers advise that what the law that the Parliament has passed actually exceeds its powers. It breaches European Union law. It breaches European Convention on Human Rights law. I mean, the way the scheme was explained there in that clip, it sounds very benign, sort of like an insurance policy and extra support. But that's, I'm afraid, not an accurate picture. This law appoints a state guardian for your child, for every child in Scotland, whether you want it or not. That person has the power to speak to your child, whether you want them to or not, to recommend them to receive services, whether you want them or not, and also, most concerning perhaps, to obtain confidential data on your child and to share that child with other agencies without your consent. It's very far-reaching. It's nothing to do with child protection. It's to do with being a kind of a co-parent, and I don't think most parents want or need that.
So you're saying that the human rights of parents are being contravened here?
Certainly, that is certainly part of the case, yes. All families have a right to privacy under the European Convention. The Convention also gives all families a right to have their children raised in accordance with their own religious or philosophical beliefs.
But isn't this just simply about offering assistance to parents? Stuart Maxwell has said that most parents will never deal with a state guardian for their children. It would only become an issue if a children is at possible risk or might need assistance.
Well, the key word in your sentence there was offering, and the thing is, the named person has power to do more than just offer. They have the power effectively to insist, and the idea that this person can obtain, for example, your child's confidential medical records without you knowing, without your consent, and sharing them, I think people will find that quite disturbing. One of the parties to the action today is a family who received letters from their local National Health Service Trust, which said, we've appointed a named person for your children. They didn't know who this was. All of your children's medical records will now be sent to them. And if you're late for a medical appointment, we'll tell the named person about that too. I think most people would find that sort of thing highly invasive. And here's another problem. It will generate so much work and so much paperwork, it will bury those responsible for child protection under a welter of new and overwhelmingly unnecessary information, which makes it sadly even more likely that children that really do need help and families that really do want help are even more likely to be buried under that pile.
But you take the point that human rights need to be balanced here. Sure, you have the human rights of parents on one side, but there are human rights of children to be cared for properly and to be looked after. And there are many cases...
parents are the best people to do that.
But not in all cases, surely.
Overwhelmingly, parents are the best people to do that. And the problem with this legislation, it doesn't once use the word family. The silent implication of the legislation is that parents are not the primary carers for their children, and that parents are in fact the primary risk to their children, and that you need the state, you need a co-parent from the state to make sure that parents are doing a good job. That's quite wrong. The primary relationship that children have is with their own parents, and then the state has a very proper role to step in where there is evidence that parents are falling woefully short.
Do you believe that the public...
And they have all the power in the world to do that when they need to.
Just very briefly, do you believe that the public are on your side? The Scottish Government say that this was supported by a large majority of those who responded to the public consultation.
I don't think most people even knew about it when the consultation was going on, but I do know that the more people hear about it through the Noted Named Persons campaign, the more they don't like the sound of it.